So you are still litigating because you enjoy it.
Yeah. So the last major hearing I had, I believe, was last year, though that's not unusual for anybody these days, since COVID has really, put a kibosh on jury trials and such. But I did a 3-day binding uninsured motorist claim. That was like a mini jury trial. We had live physicians testify and so forth.
What was that? You were starting to talk about that a little bit?
No, it's a a case that I handled that I was very vested because it was a close friend of mine, and the carrier had made an inadequate offer, in my opinion, and probably most reasonable people would agree that it was an inadequate offer. They were not acknowledging claims that were actually related, and the panel of lawyers, 3 lawyers, one being appointed by the insurance company, unanimously decided that the value of the case, I think, was about 5.5 times what they had offered.
But was that you made a mention to a limit, UIM limits, and there was something that you were involved?
No, that's referencing the Funk case that's 20 plus years ago as well. It deals with exhaustion of liability coverage before you can pursue a UIM claim. And that's not the law. The law is that you can present an underinsured motorist claim as long as you give credit to the underinsured motorist carrier for the liability limit. And the motivation behind that is some liability carrier may be difficult and not wanting to give you the full policy, and yet now you're held up on trying to negotiate your first party claim, and you have to actually go through a trial with the liability carrier to pursue your first party claim that you paid for. That's not right. So the first party carrier can negotiate, or that is, the claimant can negotiate with their first party carrier, which they've paid for the coverage and they have a contract, for an independent valuation outside and distinct from the third party without having to pursue or resolve the third party claim first. Makes a lot of sense.
Well, no, it does. But I can see things like that happening where they hold it up here. So if the third party won't even tell you what limits are.
Yeah, in some states, they don't even have an obligation, like Tennessee, to disclose the limits even when you're in litigation, which is crazy.
That is crazy.
Yeah, but just the same, it makes a lot of sense. You got a third party carrier that's holding up payment of $100,000. They only want to pay you $75 because, they think that, the cost associated with going to trial and the time and effort, it's not going to be worth it to the claimant. So as a result, they make it difficult. Well, in reality, the case is worth $150,000, but they're expecting the plaintiff to cave. Well, if the plaintiff caves and the law is you can't pursue your UIM claim until you exhaust the underlying coverage, it creates a double whammy, so to speak, for the claimant. So now, and ever since we took that case through the Court of Appeals, specifically in Arizona, you can present your UIM claim contemporaneous with the liability. You can negotiate with the UIM independently, and that claim can be resolved even before the liability claim, which makes a lot of sense because you've got a contract with your own insurance, and that's the way it should be.
I wonder if that's contrary to law up here.
It is. There's some nuances in Washington as it relates to when you can present the claim and an assignment of claim and waiver of certain claims. It's different.
Yeah. Huh.
But we took that case to the Court of Appeals a number of years ago, and it was, I guarantee you, it's cost the carriers in this state a lot of money, because I've educated all my colleagues about how to process first party claims, even though you haven't settled the third party yet.
Huh. We need somebody. Well, you're up here. When are you going to push that through up here?
Well, you got to have the right case the right facts to make it happen.
Don't tell me what the right case looks like.
Well, you know, it's really gonna be a case where there's huge value in comparison to the combined limits liability, UM and PIP, and where the first party carrier is really being difficult in terms of allowing certain claims to proceed and assignments and so forth. And I have not had the right case yet, Mike. And the reason being is because almost every one of our cases in Washington end up resolving for full value, because juries in Washington, you know, usually get it right and are pretty good to plaintiffs. And as a result, all the carriers know we got no problem trying any and every case, no matter what the size. So the carrier knows they're ended up paying anyway. So let's resolve claims with Wattel.
So, okay, that's interesting, because that has been your MO since I've known you. And I think you even taught me that, how the insurers try to train attorneys to not take certain cases, and you've kind of turned the tables on it. You've trained the insurance companies that if you've got a case, that you'll go to the mat for your client, and it's cheaper for them to pay you than to drag it out and pay billable time to a defense attorney.
Yeah, I mean, it's you want to pay your defense attorney, fine. You're going to pay your defense attorney, but you're going to end up paying me the same amount I want now anyway. So you tell me, do the math. I mean, am I always right? No, but we track our cases, and more than 95% of our clients, Washington and elsewhere, end up with more money in litigation than what was offered pre-suit. Now, that's important to understand, because that means that people out there who go to lawyers that are gun shy in filing lawsuits or are not pushing for litigation for their clients, then they're short settling cases, which has a poor economic impact upon their clients. Now, some clients may say, listen, I don't care about the money and I just want to be done. I get it. But wouldn't you rather still get the maximum amount that's potentially available in a pre-litigation setting, knowing that the carrier knows full well that you're going to be trying this case if need be, as opposed to a lawyer that's going to short settle every single time? Yeah, but it gives at least the option to the client to decide, all right, do I want to take the carrier to task and end up with more money, or take the lousy amount that's offered at this juncture?
Now, I know you're a poker player.
And so listen, the beauty is that listen, here's what irks me. What irks me beyond belief is there are some lawyers out there that will let their own pocketbook affect their recommendation to a client on a case. The beauty is that we're in a financial position, that one case or every case isn't going to affect my lifestyle. So I want, especially because of all the other things that I do, I want to be in a position where I'm not part of the equation. And in fact, it's probably unethical if I'm ever part of the equation. But I don't want to be part of the equation to decide what's best economically for a client. Well, so we all remember learning about the bell-shaped curve years ago in high school. Some of us have a more difficult time remembering based upon the passage of years, but the bell-shaped curve, it is pretty much what we follow in terms of settlements. And we want to get our clients in a position where we're at the midpoint or beyond, so that the risk-reward assessment is such that if they continue on, the risk of getting less is greater than the risk of getting more. So if we get the client to that point and beyond, then we've done a pretty good job. And then the client gets to make the risk-reward assessment. The question becomes, where is that midpoint? And the midpoint for lawyers like us that litigate and hold carriers to task is probably further along the x-axis than those that don't litigate, because carriers aren't concerned about attorneys that don't litigate, because why? They're no threat.
Yeah, right. Is your firm, at least here, in our state, are you still taking on clients? Or are you?
Oh yeah, every day.
Okay.
Every day we take on cases.
Okay.
You know, and you know, it's funny because, you know, we've not been a big advertising law firm over the years, but we're about to roll out a campaign here in Arizona for all my partners so that they can benefit from the good name that we've created. But it's going to be a pretty dynamic campaign. And then, unfortunately, my fellow friends in Washington State may start seeing my mug more often.
Way to go.
Actually,
all of our buses.
Yeah, actually, it's a jingle that essentially says, have a legal question, call Dave and Mike.
Yeah.
And it's catchy. It's the way it's sung and the music to it. It's pretty cool.
Yeah. Well,
not too cheesy.
Well, people here, I mean, people here probably don't understand what I just even said, but that's your little jingle is way to go. And, and the transits up here, that's their little jingle, way to go, across the tops of all the buses. And I've always thought that was kind of unique. Yeah,
well, we're still way, Wattel and York, though you can't use ampersand, even though we've used ampersand in a web address, you can't use it. But we're now going by calldaveandmike.com.
Do you take calls from clients?
Yeah, absolutely. I talked to a client 10:30 this morning about a situation.
Well, and you're taking time to talk to me right now.
Well, that's a pleasure. Not to say not talking to clients is a pleasure, because it certainly is. And I enjoyed the dialogue with the client this morning. He had a question, and we got into, listen, my responsibility to you is to educate and inform you so you can make intelligent decisions about your case, because it's your case. I'm your mouthpiece. I'm gonna provide you with what I believe is competent advice as to consequences and paths of travel, but ultimately it's your responsibility. And if I'm not communicating with you and I'm not giving you information, how can you make an intelligent decision? And how am I fulfilling my obligation?
Yeah. Well, I've said it before. I have a lot of respect for you, Dave, and I've learned a lot from you about even that, working with your clients and helping them to understand the best that you can. And that's the reason I'm even doing this. I mean, I got better things to do with my time, and instead of trying to put these things out, but to try to get the information and out to consumers so that they understand. Because what happens for most people is they're all of a sudden they're thrown in the midst of an accident, which can be life-changing, and then trying to figure out, what do we do? So hopefully this type of information, years ago when we did it on the radio, we had quite a following. And so we just got this going here during the pandemic because everybody's cooped up. And so hopefully this type of format will help people have a better understanding.
Well, thank you for the kind words, but you're the guy that bashed your head against the wall every day dealing with the insurance companies, trying to get them to pay for OEM parts and trying to pay for a reasonable labor rate for cost of repair, and trying to have insurance companies recognize auto manufacturers' guidelines in terms of repair. And I know how hard that task is, especially when all the other body shops out there are not willing to really get in the sandbox with you and support the same type of approach to auto repair.
Right.
So don't sell yourself short in terms of the efforts that you put forth in the past to try to help out the consumers in the community.
Yeah. Well, and thank you for that. Well, Dave, I don't want to take up any more time. I know you've got a lot to do. Really appreciate it. Next time you're up, will you give me an advanced warning, will you? I'd sure like to get together with you.
Absolutely.
All right.
Appreciate it.
All right. Take care.